May it
Yes.
please your lordships. I beg to mention an item, lordships. I filed an IA. It is of an urgent nature. Can it be taken up tomorrow or day after, lordships?
Why?
Because the wife who had been granted 6,50,000, lordships, she's willing to forego that amount because she cannot sustain with her salary. Even her maintenance has been rejected. So she wants to go back to her hometown, Dimahasao, because she has elderly parents. She'll go and stay with them. She's winding up. She's needed to go during the first week of January,
So
lordships.
matrimonial,
Yes, lordships.
who is the other side?
I have served a copy yesterday. Filed the petition. Filed the day before yesterday. Served a copy,
Okay,
lordships.
day after tomorrow, Friday.
Yes, lordships. Deeply obliged.
My lord, I beg to mention for listing one IA, my lord. This is pending since long, your lordship. 22, your lordship.
After
This is-
Bihu.
My lord, day after tomorrow if
Sorry,
possible.
rejected. Day after tomorrow, no listing. Yes,
My-
completely rejected. Why did you make a prayer?
After
for-
vacation, my lord,
After
date may be fixed, your
After
lordship.
vacation. After vacation, yes, next.
Date may be fixed, your lordship.
Nothing.
May I please your lordships?
Yes.
I need some accommodation in item number 5, 6, and 8. The advocate appearing for the respondent is in bereavement. His wife expired on 7th. Kindly
Five,
this
6, and
matter
8, you write, is submitted at the bar that the learned counsel for the respondent, namely
be Prasad.
Mr. B. Prasad, has suffered a bereavement in the family, as a result of which he is unable to attend court proceedings. On such ground, a prayer has been made to adjourn this case for 3 weeks. Since the prayer is not opposed by the learned counsel for the appellant, same stands allowed. Register to list the case accordingly. Same order in item 5, 6,
And 8.
and 8. Respondent number 2, 8 of respondent number 2, or Baki will have sole respondent. Yes,
Obliged.
Miss L. Devi, learned counsel is present for the appellant. It's 5 or 6 applicable. And in item 8, also same.
Daily list for admission, item 1.
Lordship, it pleases. Lordships, in this case, I have challenged the impugn order. I think too.
May I please, your lordship, appeal against conviction for 14 years under section 376(2) F. Then the appeal will be admitted. The notice will go to the respondent number 2.
For the appellant also heard Ms. S. John, and appearing for the state. Criminal appeal is directed against the judgment and order dated. Judgment dated 21/10/2024 and order dated 24/10/2024, whereby the appellant herein has been convicted under section 458, read with section 376.
2F.
Huh?
372F bracket.
376 bracket 2F of the IPC and sentenced to inter alia undergo rigorous imprisonment for
14 years,
14 years and also to pay fine of rupees
1 lakh.
1
in
lakh
default
with
3 months.
Default stipulation, first up. We peruse the grounds taken in the memo of appeal. Admit the appeal, calls for the LCR, issue notice returnable in 4 weeks. Since Ms. Jahan, learned APP Assam, has appeared and accepted notice for respond number 1. No formal notice, respond number 1, oblique straight. No formal notice is required to be sent to the state respondent. Appellant to, however, takes steps for service of notice upon the
Respond number 2,
informant.
inform.
Stroke respond number 2 by registered post with ID.
So PP will serve to the concerned police station.
376 2F perhaps
Oh,
is not
same thing.
included
Same
in
thing.
Deepak Nayak's case. 376
Send
AB is
notice,
there.
Then we'll see. And there is a
AB
IA,
I is there.
so and so for the applicant, so and so for the state. His IA has been filed under section 430.
430,
432.
430 clause 2.
Clause 2.
430 clause bracket 2 of the BNSS with a prayer to suspend the jail sentence and also to release the applicant on bail. Full stop. The prayer made in the IA shall be considered on receipt of LCR. The state may, in the meantime, file objection if so advised.
Ma-
Is what-
May I please your lordship, I am appearing on behalf of H.R.A. Chaudhary. This is statutory appeal. Lordship, appellant convicted under section 120B 302 and 392 lordship IPC.
All right, your name
Lordship,
please?
at this stage, appeal may be admitted and
Name,
LCR may be called for lordship. At this
Name.
stage, appeal may be admitted lordship.
What is your name?
Name your name.
R. Deca lordship.
Heard Ms. R. Dekal and counsel appearing for the appellant. Also heard Ms. S. Jahan and APP Assam appearing for the state. His appeal is directed against the judgment and order dated 28/11/2024, passed by the learned additional session judge, Bijni, in sessions case number 184 bracket B bracket close oblique 2018, convicting the accused appellant. I go to case number to the accused appellant under section 120 bracket B bracket close oblique 302 oblique 392 of the IPC and sentencing him to inter alia undergo rigorous imprisonment for life and also to pay a fine of rupees 50,000 with default stipulation. So we have perused the grounds taken in the memo of appeal, admit the appeal, call for the LCR, issue notice returnable in 4 weeks. Since Ms. Jahan has appeared and accepted notice for the state oblique respondent, no formal notice is required to be sent in this case.
Lordship, I raised here.
Yes. IA
Obliged, Lordship.
IA is filed under which provision?
Section
Oh, she has written 389 only. Needs
corresponding
430.
430.
Oh, yes. 430 is also written here, corresponding to section 430.
I have written lordship.
Heard so
430.
so and so for the applicant, so and so for the state. This IA has been filed under section 430 of the BNSS, 2023, with a prayer for suspension of jail sentence and also for release of the applicant on bail. The prayer made in the IA will be considered upon receipt of LCR. The state may, in the meantime, file objection if so advised.
Obliged, lordship.
Item 4.
This is an appeal matter against equitable manner filed by the Milord victim, the elder brother of the Milord deceased person.
Heard Mr. D.A. Crane, learned counsel for the appellant, also heard Ms. S. Jahan, learned APP Assam appearing for the state. Here notice is to be issued
Notice to the accused persons
before admission.
before admission.
His appeal is directed against the judgment of acquittal dated 6/9/2024, passed by the learned session judge, South Salmara, Mankacha, in connection with sessions case number 10 of 2021, bracket new. Full stop. We have perused the grounds taken in the memo of appeal. Issue notice returnable in 6 weeks. Since Ms. S. Jahan, learned APK Assam has appeared and accepted notice for the state stroke respondent number 1. No formal notice is required to be sent to the state respondent. The appellant to however take steps for service of notice upon respondent numbers 2 to 6 by register post with AD.
LCR may be confirmed Milord, those Milord.
First, let us see if there is anything to admit.
Supplementary list for admission item 19.
And this is appeal against conviction, my lord, under section 6 of the POSCO Act, my lord. Conviction for 20
Well,
years.
Mr. T.J. Mahato, Royal Senior Counsel, assisted by Mr. A. Boral, and counsel for the appellant. Also heard Ms. S. Jahan, learned APP Assam appearing for the state stroke respondent number 1. This appeal is directed against judgment and order dated 13/9/2024, passed by the learned additional session judge cum POXO, additional session judge cum special judge, bracket POXO, bracket close, Sivsagar, in special bracket POXO, bracket close, case number 73/2023, convicting the accused stroke appellant under section 6 of the POCSO Act 2012 and sentencing him to undergo rigorous imprisonment for 20 years and also to pay fine of rupees 10,000 with default stipulation. We have perused the grounds taken in the memo of appeal, admit the appeal, call for the LCR, issue notice returnable in 6 weeks. Since Ms. Jahan has appeared in accepted notice for respondent number 1, no formal notice is required to send to the state respondent. So, appellant to take steps for service of notice upon the respondent number 2 informant
My lord.
by registered post with AD within a week from today.
430 application is there, my lord.
So and so for the applicant, so and so for the state. His application has been filed under section 430 of the BNSS 2023 with a prayer to suspend the jail sentence of the applicant and also to release him on bail. The prayer made in the IA shall be considered upon receipt of
Keep
LCR. The state may, in the meantime, file objection if so advised.
Keep.
Right. Appeal against conviction matter. Offense under section 302, 325, 323, etc.
All right, you take down heard Mr. M. Hussain, learned counsel for the appellant. Also heard Ms. S. Jahan, learned APP Assam, appearing for the state stroke respondent. This appeal is directed against judgment dated 5/10/2024 and order dated 7/10/2024 passed by the learned additional session judge, Bilasipara, Dhuvari, in connection with sessions case number 108/2001, whereby the appellants stroke accused persons have been convicted under section 302/325/323/149 IPC, and each of them have been sentenced to undergo rigorous imprisonment for life and also to pay a fine of rupees 20,000 each with default stipulation. Each of them have been inter alia sentenced to default stipulation. We have perused the grounds taken in the memo of appeal, admit the appeal, call for the LCR, issue notice.
He's not made a party here.
Who is not made party?
The informant,
Informant is not necessary.
not necessary.
Returnable in 6 weeks since Ms. Jahan, learned APP Assam has accepted notice for the state. No formal notice is required to be sent in this case. Let the matter be listed after receipt of LCR.
Yes, IA is there, my lord.
IA same लिखी को M Hussain, so and so, बाकी ही नहीं क्या होगा same. State may file objection.
Obliged.
For order, I can say.
May I please your lordship, my lord? In the there's an IA, my lord, in this criminal appeal. And you took time, no, you.
There is not an IA. There is an appeal in this IA. The
Yes,
IA has been
yes,
listed.
your lordship. In that IA.
I'll file it within 2-3 days, Lordship. I have not filed, he said. No. Somehow I missed perhaps.
4 weeks time was taken, my lord. It was directed to be listed on 12. No, I'll show you.
I missed it perhaps, sir.
Perhaps you missed it. Take it.
Immediately on reopening.
Immediately on it.
Mr. Z. Kamal, our senior counsel, is present on behalf of the applicant. Ms. S. Jahan, and APP Assam submits that due to oversight, the objection of the state could not be
No,
filed.
you didn't take one file.
The learned APP assures this court that within 3 days from today, the objection will be brought on record. Taking note of the brought on record, post of the matter be posted again immediately on reopening of the winter vacation.
My lord, on 6th, my lord.
Taking note of the request made by learned APP Assam, this matter is directed to be listed again on 6.
Much of
But 6, so many cases are listed, nothing will happen.
Third
Nobody
one,
is concerned about
Can I
this.
have it on 8 or 9, my lord?
9th.
My lord, let it be on 9 then.
9th.
Yes, my lord. Your lordship, much obliged has pointed it out. Yes. Just take fine.
maybe there.
Yeah, thank you. You're like expert on that.
No.
Yes. May please your lordship.
Yes.
Lordship, my senior would be appearing his legs in court number 1, lordship.
No, why this matter has been listed today?
I think a report was called from the OC and Mr. Komal was there, in the matter. Report to service of notice on respondent.
Yes, have you got the report? Service
Lordship,
notice?
I'll take the instruction. I was not there on the last occasion. I'll take the instruction. It is
But your
written to obtain
APP
report.
keeps changing and then every time
This is what,
you'll change APPs and then matters will get,
immediately on the reopening, I'll get the instruction.
we'll have it. Yeah.
On third, of-
Heard Mr.
G.R. Sinha, lordship.
G.R. Sinha, counsel for the appellant peruse the order dated 6/9/2020
give on the school.
passed by this court whereby the learned APP Assam was asked to obtain report from the officer in charge of concerned police station as regards service of notice upon the respondent number 2 stroke informant. First up, today when the matter is called up, Ms. Jahan, learned APP Assam submits that since another APP was handling this matter earlier, hence she is not in possession of the report. Full stop. The learned APP, however, seeks posting of this matter immediately on reopening of the winter vacation, so as to enable her to produce the report, if any, before this court. Full stop. Report Lihibo, Mr. N. Bora, instead of G. Sinha N. Bora. Prayer allowed, register to release this case after the winter vacation, so as to enable one more chance to the learned APP Assam to produce the service report. Let it come.
Obliged. Item 10 was supposed to get the instruction from the OC. It is served on the daughter of the informant. Because the informant nowadays works in Arunachal Pradesh and she was apprised of through WhatsApp and all. Otherwise, notice is served upon the daughter of Kulsuma.
Daughter of?
Kulsuma, the informant.
None appears for the appellant when the matter is called up. Ms. S. Jahan, learned APP Assam, has appeared and produced copy of the communication dated 16/12/2024, issued by the officer in charge of Ungalmora Outpost, Police Outpost, to submit that notice of this appeal was served upon the daughter of the informant. Full stop. It is also submitted by learned APP Assam that the notice of the appeal was also sent to the informant through electronic means. Full stop. After perusal of the communication dated 16/12/2024, we are of the view that which section is involved here?
This is FOXO. This is FOXO. This is section 4.
The appeal need not be detained any further on the ground of service of notice upon the informant. Full stop. Register to therefore verify if any counsel has entered appearance on behalf of the informant stroke respond number 2, and if not, a legal aid counsel be engaged so as to represent the interest of the informant respond number 2. Full stop. Let this matter be listed again after 4 weeks by reflecting the name of the legal aid counsel in the cause list. Full stop. A copy of the communication dated 16/12/2024 be retained in the record.
Item 11. We file an objection in this case, no? My learned friend is.
My lord, in this case, my lord, petition appellant before your lord.
Establish the charge beyond reasonable doubt. No person can be punished and no person can be convicted and punished to to suffer jail sentence. And line tag equitable. Yes,
Lordship, evidence of PW 27, the IO, your lordship.
yes,
May I read it?
yes, page
Uh,
number.
No, I'm reading from the evidence.
Yes. No, you are
Lordship.
reading from something. is
No,
that-
from records, LCR. Evidence of PW 7.
Mhm.
Lordship, the relevant portion I read out, PW 27.
No, but we wanted to see it while you are reading.
Yes,
not
my
from-
lord. Oh.
Page
Lordship,
number,
no, it's on the original
In
record.
my case, madam, PW 27 is 145. In my IA, madam.
145.
Yes,
Yes.
Ramcharan Rava.
Ramcharan Rabha, my lord, on the next page, third line. The mobile phone of the accused, has your lordship found it?
Yes.
The mobile phone of the accused and the mobile phone used by Rule Nursery were sent to DFS Kalipara. And it was found from the report that a message was sent from the mobile phone of Rule Nursery to Chilarai Nursery. The message sent by Rule Nursery to Chilarai Nursery was that the accused has committed rape on her and that is why she is going to commit suicide. In the course
Just a
of
minute, just a minute. You are reading the evidence of PW 27.
27, the next page of the evidence, third line.
Yes.
The mobile phone of the accused and the mobile phone used by Rule Nursery were sent to DFS Kailipara. And it was found from the report that a message was sent from the mobile phone of Rule Nursery to Chilarai Nursery. The message sent by Rule Nursery to Chilarai Nursery
Rule
was
Nursery is the
the
victim.
victim. Was that the accused is
For filing objection, let the matter be listed accordingly. Yes.
phone number to लिख दीजिए. लिखिए नहीं.
May I please the
Contact
lordship?
number to लिख दीजिए.
My lord, this IA is for suspension of sentence pending appeal, release of the appellant on bail, my lord. And last time, my lord, criminal appeal is admitted. My lord. This notice may be kindly allowed to be issued to the respondent number 2. Similarly, my lord, with the criminal appeal, my lord, at this phase, my lord.
Notice one है ना?
Notice one,
Pokso नहीं.
Foxon, no. 302.
Conviction is under which section?
My lord, 302, my lord.
You want to file objection?
Lordship. Okay.
302 informant is not required.
May not be required, but participatory right we have.
But she has made the informant a party.
Lordship, the notice be issued.
Heard
by
Ms.
registered
DRS
post.
Sultana, learned counsel for the applicant, also heard Ms. B. Bhuya, learned APP Assam, appearing for the state oblique respond number 1. This IA is filed under section 430 of the BNSS 2023 with a prayer to suspend the jail sentence imposed upon the applicant by the judgment and order dated 6/9/2024. Passed by the learned additional session judge number 2, Tinsukia in sessions case number 135 bracket T bracket close oblique 2023 under section 302 of the IPC. Full stop. Ms. Bhuya, learned counsel for the learned APP Assam, prays for some time to file objection. Issue notice returnable in 3 weeks. Since the learned APP Assam has appeared for the state respondent number 1, applicant to notice be sent to the informant respondent number 2 by registered post with AD within a week from today.
Also.
The IA is for condonation of delay of 30 days in preparing the appeal.
Pokso नहीं.
POCSO.
What is this, POCSO?
POCSO. Section 4 POCSO.
So POCSO informant has to be heard, victim has to be heard.
Yes.
And we have to know issue notice, otherwise we would have condoned the.
Yes, 30 days.
No,
Yes, he has to be heard. It's up to your lordship before issuing
we
notice.
issue one notice
Why
and then
not?
we'll see heard, Mr.
I am on behalf of Mr. S. Biswas. He is in bereavement.
Whose name should be recorded?
I am a proxy counsel on behalf of Mr. S. Biswas.
Oh, proxy person.
No, he is in bereavement, Mr. S. Biswas.
Mr. S.
We'll
Biswas.
record his name then. Heard Mr. S. Biswas, learned legal aid counsel appearing for the applicant. Also heard Ms. B. Bhuya,
Report
learned
any?
APP Assam appearing for the state. This IA has been filed under section 5 of the Limitations Act 1963 with a prayer to condone the delay of 30 days in filing the connected criminal appeal. Full stop. It appears that conviction of the applicant was under Section 6 of the POCSO Act.
Section 4.
Section 4 of the POCSO Act 2012. As such, notice will have to be issued to the informant. Full stop. Issue notice returnable in 4 weeks. Since we have learned APP Assam has appeared for the respondent number assisted by Ms.
Ardas.
Ardas. And counsel has appeared for the respondent number 1. No formal notice is required to be sent to the said respondent. Notice be sent to the informant respondent number 2 by registered post with AD within a week from today. Yes. you are
Lordship,
appearing.
the main.
Yes, Your
Yes.
Why you did not appear? in the-
Lordship, we just somehow missed out. I apologize before this honorable court. We somehow missed out because there was some other matters for of my senior in other court.
More important matter.
There was a cross examination. I was assisting him.
That is more important, obviously. Yes, what is this case about?
Lordship, my case for guardianship was rejected. Not even a single occasion the other side has entered appearance. But in her absence, your Lordship, the order was passed against me ex parte order. Lordship, prior to the day's order, Lordship, order of settlement arrived between the parties, and there
Lord Mayor, please, Lord. My senior is Kaimullah. I may be allowed to start.
Yes, some instructions were required.
Yes, Lordship.
Give the BNSS, please. BNSS.
I have annexed a list of 25 witnesses, Lordship. In fact, my instruction is, Lordship, not 25, it will be less. And it should end by March, Lordship.
No, but please come to 479 of BNSS.
BNSS पण पाहता असं म्हणजे. किती वेगळं असं म्हणजे. किती वेगळं असं. BNSS असं नाही. Okay, okay. ठीक है, okay.
So which are the sections involved?
Lordship, Insofar as
It's,
IPC,
my lord, 120B, 212, 121A, 420, 468, 471,
120B, then,
212, my lord.
then,
My lord, 121, 121A, 420, 468.
so some of these provisions, are they still there under the new?
It is there, my lord. So 121 has been diluted, I believe, my lord, the equivalent one. But now by the saving clause, my lord, this case will go by the old act provisions, my lord.
When the,
When the occurrence took
Offense,
place as on that date, my lord.
all right, so what is the maximum punishment under
My lord,
this?
life imprisonment.
Life imprisonment, not death.
No, no. Life imprisonment, death, I didn't look into it.
not that's.
It's
Huh?
life only,
Life.
unlawful.
And is he a first time offender?
Yes, my
Was he
first time,
convicted
first time.
earlier?
No, 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 no,
No.
no, no, no.
Then what about 479 BNS
My lord,
subclause 2?
that will not apply with all
why-
respect,
why?
though, because as I understand, my lord, my duty to point out fairly, my lord, because when the sentence is life, then I think BN, that 437A probably your lordship is saying.
Not 437,
Yeah.
479.
479.
Section or is it?
479. Assess. देखो नहीं याद आती
So 479 does not have anything to do in your case. Is that? Huh?
Because, yes, my lord, because of the fact, my lord, not being an offense for which the punishment of death or life imprisonment has been specified as one of the punishment under the law.
Yes, give me those orders. Two orders.
Assess. मुझको नहीं याद है
Yes, when was he arrested?
My lord, he was arrested on 11/6/2012. My lord, we can give the date of dates, my lord. Sorry.
बस assess.
FIR was lodged on 24/11/2011 and I was arrested on 11/6/2012. And since then, I'm behind the bar, facing the trial as an UTP, my lord.
And his wife was granted bail.
Yes, by your lord.
Where is it? Where-
I have annexed the order, my lord.
Yes, page number.
My lord, it's 60. 80, my lord, 79, 80, yes. Annexure 3, my lord. Now, she has settled in life, my lord. With
Sorry?
she has settled her life out there
She has
in her native place, Manipur, my lord. With the kids going to school and all.
She was granted probably during 5 years plus in creation. By the- At that time, my lord, this Najibs and all this were not there, my lord. In spite of that, taking into consideration also Watali, my lord, your lordship was pleased to grant her bail, my lord. So there were 6 accused persons, is it?
Yes, on the whole, my lord.
And how many are on bail?
For only 2 are behind the bars, my lord. 4 are granted bail, my lord.
Which page is the impugned order?
My lord. Lastly, my lord. 105 will be the running page, my lord, and the main part is at 107. When did he? It was correct purpose. It was to भूल purpose. Rajendra को complete.
What is the allegation that he has collected money?
Lordship, the witnesses I would refer to
No, I'm here.
Lordship.
What is the allegation against the?
that he is the chairman of a particular underground group, Lordship.
Hmm.
The group has collected money. It's not that he himself, but there are instances to show that on his instruction, somebody has been kidnapped, ransom has been taken by this organization, Lordship.
So 12 years plus under trial prisoner.
Lordship.
What remains?
That is their Lordship. Well, 17.14 of Russell. Because
Recently, one judgment just come by wherein 7 witness was late, but that is also a long period of time that court has said. In lordship, but of course, in an NDPS case, which is more stringent. Private speakers will go in there, everyone will go to Morak like this. Private. Oh.
So this is the first application before the High Court.
Yes, madam, first. And your lordship wanted to know why so much of delay, and then we have filed an additional affidavit. On the last date, your lordship made a query, and accordingly, we have filed the affidavit.
What is the explanation?
Explanation is that, my lord, immediately after the bail was rejected, my lord, the wife and the children are all inside together. There was no communication between his native place and all to come and take steps. So when the wife got released, my lord, she filed a petition, my lord.
What is there in Sheikh Javed Iqbal's case? Which para is relevant?
My lord, Sheikh Javed Iqbal cases, it categorically said, my lord, that taking K. Najib and this Watali's case, and then it has distinguished it, my lord, that even that because of the long incarceration, my lord, the rights cannot be violated.
Which
My lord.
paragraph?
Para 32, my lord. This court has time and again emphasized that right to life and personal liberty
enshrined under Article 21 of the Constitution of India is overreaching and sacrosanct. A constitutional court cannot be restrained for granting bail to an accused on account of restrictive statutory provision in a penal statute if it finds that the right of the accused under Article 21 of the Constitution has been infringed. In that event, such statutory restriction would not come on the way. Even in case of interpretation of penal statute, howsoever stringent it may be, a constitutional court has to lean in favor of the constitutionalization and the rule of law, which liberty is an intrinsic part. In a given facts of a particular case, a constitutional court may decline to grant bail, but it would be very wrong to say that under a particular statute, bail cannot be granted. It would run counter to the very grain of our constitutional jurisprudence. In any view of the matter, K. Najib being rendered by a 3-judge bench is binding on a bench of 2-judge bench like us. And accordingly, the bail was granted. In between, Gurvinder came in, my lord, prior to this. Then that was also distinguished in this case, my lord, how Gurvinder is again not applicable when Article 21 stands in a higher pedestal.
What has been held in K. Najib? Let us see the.
Yes. Here, Najib, my lord, we will have to start with 3-judge bench, 2021 3 SCCB. Here, Najib, actually it happened, my lord. One of the accused was already convicted for 8 years. Then he was allowed to, he was released. Subsequently, the absconding accused was arrested, my lord. In that context, this judgment was passed, my lord. Para 13, it starts, my lord. The main para is 15. Shall I read, my lord?
Just 1 minute.
Sure, my lord.
And in Gurinder, what has been said? Gurinder Singh?
Gurvinder distinguished it that in this context, Najib was granted bail because 8 years sentence is already there. So that was taken into consideration, and Gurvinder was distinguished that since it is 8 years of punishment, that's why already it has been established. So we can distinguish it that way. I'll take your lordship to that para. Para 45. In K. A. Najib's case, this court was confronted with the circumstance wherein, except the respondent accused, other co-accused has already undergone trial and were sentenced to imprisonment of not exceeding 8 years.
Therefore, this court decision to consider bail was grounded in the anticipation of the impending sentence that the respondent accused might face upon conviction. And since the respondent accused has already served the portion of the maximum imprisonment more than 5 years, this court took as the factor influencing its assessment to grant bail. Further, K. Najib's case, the trial of this respondent accused was severed from the other co-accused owing to his absconding, and he was tracked back in 2015 and was being separately tried thereafter. And NIA has filed a long list of witnesses that were left to be examined with reference to the said accused. Therefore, this court was of the view of unlikelihood that the completion of the trial in the near future. However, in the present case, the trial is already underway and 22 witnesses, including the protected witness, have been examined. This is the distinguishing feature. Since already 8 years is already awarded, my lord. So the question of life and
So he is the chairman of a banned terrorist
yes,
organization.
my lord, that is the allegation, my lord. But till now, the evidence that has come on record, if I gone through it, my lord, nothing as such has been established, my lord.
So he says by March they will conclude the trial.
My lord, there is doubtful how can they,
Otherwise, they will lose their.
I have always appear, my
Worship,
lord, I default.
That is a statement that I have given before this court on instructions, Lordship. But taking in view my senior's anxiety, Lordship, my submission would be, Lordship, can have it in the month of March. If not, Lordship may consider it. Because the other case relied by my senior, Javed. Javed's case, Lordship, there was only one witness examined in a long period of 8 years. That is why the court followed K. Najib. The only one witness was examined in a period of 8 years.
But 12 years have gone.
Lordship, I do understand, but in between, Lordship, there was the COVID and all, Lordship.
Yeah, that was also.
And there are other constraints, Lordship. Off the record, I can say.
Ananya.
Yes.
Off the record, I can say, Lordship. Manipur is very difficult to summon somebody. It's very difficult. Nobody will go and give the summon.
That is all the more reason because
So, Lordship,
All said and done, my lord, but article.
life in prison could be 15 years. He has already
14.
served 14 years. He has already served. Maximum punishment is life imprisonment. He has been in jail since more than 12 years now.
Yes.
12 and a half years.
Lordship,
12, exactly 12 years, 6 months, 7 days.
Lordship, that I cannot.
MND.
But Mr. Z. Kamal Lanit, Senior Counsel, assisted by Mr. K. Senior Lanit, Counsel appearing for the appellant. Also heard Mr. R.K.D. Chaudhary, Lanit, DSGI, assisted by Mr. P. D. Bharadwaj, Lanit Counsel representing the respondent stroke NIA. This appeal is directed against the judgment and order dated 14/11/2023, passed by the learned Special Judge, NIA, Assam, Guwahati, in Miss MISC dot bracket NIA, NIA bracket close, case number 30/2023, rejecting the bail prayer of the appellant, primarily on the ground that in view of the decision rendered by the Honorable Supreme Court in the case of Union of India versus K.A. Najib, reported in 2021 bracket close 3 SCC 713 and THWAHA Hawa Fasal FASL versus Union of India bracket CRI APL number 1302/2021 bracket close. Only the constitutional courts invoking powers under Article 21 of the Constitution of India can grant bail to an UTP who is facing trial in respect of charges framed under the UAPA Act, considering the prohibition imposed by section 43D bracket numerical 5 bracket close of the proviso to UAPA. Is it, where is the
It's a
UAPA?
proviso to section 43.
A proviso to section 43D bracket 5
Well,
of the UAPA. Full stop. Before dealing with the legal issues raised by the parties, it would be pertinent to note the facts of the case. Stop. Based on, there was an Ejar.
yes,
Yes,
Based on Ejar dated, what's the Ejar?
SR dated 2011.
24/11/2011.
Yes, ma'am. More details your lordship will find in the charge sheet at page 60, my lord.
NIA case bearing number RC-03. Please tell me if the figures and facts are correct.
Yes, yes, sir.
Because we don't have the time to
Yes,
go all these things.
In the, on the cross title page, my lord.
Otherwise, we will have to
Yes.
keep coming for correction.
Yes, my lord, sure, my lord. Petitioner that he was arrested on him in connection with Nia.
Just a minute. We are now on which case? What is the case number?
Yes, my lord, RC 03
RC-03.
2011
2011
/ Nia
/NIA
dash Guwahati.
-GUA
Case registered under section 120B,
was registered under section
120B,
120B,
121,
121A,
121A IPC.
/420.
My lord, at that time, it was not registered. Charge sheet was filed on that. Your lordship will find at page 4.
121 of the IPC.
Yes.
Read with section.
Read with section 10/13 of the UAPA Act 1967.
10/13 of the UAPA 1967.
1967. yeah.
So he
Then-
was arrested during investigation.
Yes, my lord. The investigation one, and because of this statutory period, the charge sheet was filed, my lord.
Then you have.
The lordship will get at para 4, my lord.
The
on-
basic allegation against the appellant was that he was the chairman of a band.
Actually, in the charge sheet, my lord, he is the commander in chief.
Is that the appellant is the commander in chief of a banned terrorist organization operating from the soils of Manipur, which was responsible for extortion and collection of ransom upon kidnapping.
Yes, that is also.
Stop. On 11/6/2012, the appellant was arrested. Full stop. Initially, the NIA had submitted charge sheet on
On 7/12/2012.
7/12/2012.
Now shall I give the section?
Yes, under section.
Under section 120B, 121, 121A, 420, 468, 471 IPC,
468, 471
one
IPC.
IPC, my lord.
Read
Read
with
with
sections.
10, 13, 17, 18, 20, 38(2) and 39(2) of the UAP Act 1967.
67. Thereafter, supplementary charge sheet
Yes.
was submitted by the NIA. Again on, do you have the date?
Were given in the affidavit. My supplementary charge sheet, first one dated 30/12/2013.
Thereafter, supplementary charge sheets were submitted on
30/12/2013.
30/12/2013 and thereafter again on what?
Again on 36/2014.
36/2014. Full stop. Since his arrest on 11/6/2000, full stop. In all, there were 6 accused persons in this case, including the appellant, and his wife, namely Lakshmi Devi, who were all made to face trial from custody. Full stop. Full stop. In the meantime, by order dated 3/1/2023, passed by this court in criminal appeal number 79/2022, MS Lakshmi Devi, that is the wife of the appellant, has been released on bail. Full stop. The instant appeal has been filed against the judgment and order dated 14/11/2023 by urging several grounds. Full stop. The primary ground urged by the appellant is that the maximum punishment permissible in this case would be life imprisonment. Full stop. However, the appellant has already served 12.5 years in jail as an under trial prisoner. Full stop. Therefore, it is a fit case to release the appellant on bail only on such count. Full stop. Mr. Kamar, learned senior counsel for the appellant, has also argued that a number of witnesses are still to be examined.
I can give the precise number.
Examined by the prosecution, bracket NIA, before the trial court. And therefore, it is evident that there will be further delay in conclusion of trial. Under such circumstances, submits Mr. Trial and Mr. Kamar. Detention of the appellant in custody. Further detention of the appellant in custody would be in utter violation of the fundamental right of the appellant under Article 21 of the Constitution of India. Full stop. In support of his above arguments, Mr. Kamar has placed reliance on the decision of the Supreme Court rendered in the case of what is this, Najib? Union of India versus K full stop A full stop Najib, reported in 2021 bracket close 3 SSC 713, to submit that when the personal liberty of the citizen is at stake, the Constitutional Court must come to his rescue by invoking powers under Article 21 of the Constitution. Full stop. Next, by referring to the decision of the Supreme Court, recent decision of the Supreme Court rendered in the case of Sheikh Javed Iqbal, alias ASHFAQ Ashfaq Ansari, alias Javed Ansari, reported in 2024, bracket close 8 SCC 293. Mr. Kamar has argued that this is a fit case where this court should exercise its constitutional powers and grant bail to the applicant by ignoring the bar, if any, imposed by Section 43D bracket 5 of the UAPA Act 1967. Stop. Responding to the above submissions, Mr. RKD Chaudhary, learned DSGI, at the very outset submits that the prosecution intends to examine another 25 witnesses, bracket approximately. Full stop. However, due to the prevailing circumstances in the state of Manipur, securing the attendance of the witnesses is being hit by unexpected delay. Full stop. Insofar as the prayer made by the appellant is concerned, Mr. Dev Chaudhary has invited the attention of this court to the provisions of 43 D5 D(5) of the UOP, the UOPA Act, to submit that, having regard to the seriousness of the offense alleged in this case, this court may take an objective view. Is it objective view on the on the prayer made by the appellant, keeping in mind the ground realities? Full stop. We have considered the submissions made at the bar and have also gone through the material and report. Full stop. At the very outset, we found that what is of glaring significance in this case is the fact that the appellant, being an under trial prisoner, has already spent more than 12.5 years in the jail custody, facing trial in respect of offences, the maximum sentence whereof is of life imprisonment. Full stop. Ordinarily, this fact itself would be sufficient for this court to allow the appeal filed by the appellant, particularly in view of the submission made by Leonard DSGI, stating that the prosecution intends to examine another 25 witnesses before bringing curtains to the evidence of the prosecution side. Full stop. Examining 25 witnesses, 25 more witnesses in the prevailing situation in the state of Manipur, which is hit by unprecedented social disturbance, undoubtedly would take considerable amount of time, thus signifying that the trial is likely to be delayed even further. Full stop. In the case of K.A. Najib, a 3-judges bench of the Honorable K.A. Najib Supra, a 3-judges bench of the Honorable Supreme Court, has taken note of the numerous judgments of the court whereby it has been held that the liberty granted by Part 3 of the Constitution would cover within its protective ambit not only due procedure and fairness, but also access to justice and a speedy trial. Full stop. A speedy trial by observing that under trials cannot indefinitely be detained pending trial. Full stop. Full stop. By referring to the restrictions imposed by Section 43-D (5) clause of the UOPA, the Honorable Supreme Court has made the following observations in paragraph 17, which are reproduced herein below. Full stop. Next, the decision in the case of K.A. Najib was followed by a 2-judges bench in the case of Sheikh Javed Iqbal Supra, wherein a similar view was expressed in para 32, which is reproduced herein below for ready reference. Full stop. Full stop. Our attention has been invited to a decision rendered by the Supreme Court in the case of Gurvinder Singh versus State of Punjab and others, reported in 2024 (5 SSC 403), wherein it has been held that mere delay in trial pertaining to grave offences cannot be used as a ground to grant bail. Full stop. However, the decision rendered in the case of Gurinder Singh Supra has been explained and distinguished in the case of Sheikh Javed Iqbal Supra, whereby the latter decision has followed the view accepted by the larger bench of the Supreme Court in the case of K.N. Ajib. Full stop. Having regard to the peculiar facts and circumstances of the case, and also the fact that the appellant has been in jail custody for more than 12 years, facing incarceration during trial, we are of the unhesitant opinion that this is a clear case where the fundamental rights of the accused appellant, guaranteed under Article 21 of the Constitution, has been unduly infringed. This we say so more particularly on account of the fact that the maximum punishment, the fact that as noted above, the maximum punishment that could be awarded to the appellant in this case is admittedly life imprisonment. First up, for the reasons stated herein above, this appeal succeeds and is hereby allowed. The judgment and order dated 14/11/2023 is hereby set aside. Consequently, the prayer made by the appellant for grant of bail stands allowed. The appellant will be released on bail. Appellant so-and-so shall be released on bail on furnishing a bond of ₹2 lakhs and 2 surety of like amount to the satisfaction of the learned special judge Nia Guwahati. We also make it clear that the learned special judge Nia Guwahati shall be entitled to impose any other additional condition upon the appellant for his release on bail if so deemed necessary. Before parting with the record, we make it clear that the observations made herein above are purely for the purpose of disposal of this appeal and for consideration of the bail prayer made by the appellant, and the same shall not have any bearing during trial of the pending case before the learned special judge Nia.
From my side, I'd like to say one thing, my lord. If he has any passport, he should surrender, my lord, because we also want that
All
if he is guilty.
Are we at a debo? Before additional condition, we also direct the appellant to surrender his passport before
If
the
any.
special judge Nia.
We don't know, my lord, if anyone.
Passport, if any. Passport and oblige or any other travel document,
Yes.
if any,
Right.
before the learned special judge Nia, before securing his release on bail. বাকি খিনি এখানে থাকিব।
Much obliged.
So Mr. Kamar, anything else? Are you coming up with anything else before vacation or?
No, my lord, nothing else.
No, no, nothing for now. Just
Nothing
if he comes up, I'll have to come. Nothing for now.
All right, it's all done.
So let us peacefully go into a
Yes, all we did,
winter
my lord.
vacation. All
So
right.
nice of your lordship, my lord. Much obliged, my lord.